Hello and welcome to the MBAM Portal for Construction Law. This is a continuing series on legal issues to consider before you expand overseas. You've done all you can to safeguard your expansion overseas. You've created the proper structure. You've properly thought out your employment contracts. You understand the tax implications. You have protected your intellectual property. You are familiar with the contractual terms. So it's all hunky-dory, right? Nothing can go wrong, right? But something always goes wrong. See, construction is the coordination of a million moving parts. And therefore, something will always go awry in the process. And that is why we come to the topic of today's video, which is dispute resolution. Dispute resolution clauses in an agreement are oftentimes ignored. Because it's like thinking of divorce at the start of a marriage. Nobody wants to think about it. Dispute resolution is expensive. It is messy. Now imagine if you have to do it overseas. Imagine if you are having a dispute resolution process overseas against a local party who has all the connections, resources and convenience to attend hearings, to go to preliminary discussions, etc. It is critically important if you are going overseas, if you are expanding your business overseas, that you move the dispute resolution to arbitration and not rely on the local court process. Now, although arbitration clause is just usually a single clause in a contract, but in law we call that an arbitration agreement. In other words, the law regards that single clause as a separate agreement from the main contract, which also means that the law of the contract need not be the same as the law of the arbitration agreement. So you can set the law of the arbitration agreement. Personally, I would strongly recommend the AIAC. We've got world-class facilities, very competent arbitrators, and very strong support for arbitration by the national courts. And frankly, much cheaper than Singapore. But there are great neutral jurisdictions all over the world. Singapore is a great example. Hong Kong, London, even New York. These are all good centers for arbitration. Arbitration is also less concerned about legal technicalities. So you can focus on the substance of your disputes. You can determine the language to be used. You can decide on the qualification of arbitrators. You can decide the number of arbitrators. You can set your venue. All of these will be critically important if you are facing an international dispute. Because the last thing you want is to be caught in a local court system conducted in a language that you're not familiar with by a local judge who may not understand construction issues. And to top it off, you are having to fly all your advisors, all your witnesses, cart all your evidence there against a counterpart who may be living 30 minutes down the road from the courthouse. So make sure your dispute resolution clauses are thought out properly. Now, I have not even touched on multi-tiered dispute resolution clauses, as well as dispute avoidance clauses. So there's truly very much more on this subject that we can touch on these short videos. But take care of the dispute resolution, and in the final video of the series, we'll talk about enforcement.